penalty, the amount, as you would have seen, is only 2% of the average turnover. We can go up to 10%. We've imposed more penalty in many other cases. So it's actually a penalty which is on the lower side. And let me tell you why it's on the lower side and why we've sort of kept it at that level. There is a market for spare parts, for maintenance, equipment and so on, as distinct from the market for primary cars.
That's right.
It's nobody's case, and that hasn't come to us, that there is distortion in the market, primary market for cars, but that in the market for equipment and repairs, maintenance, diagnostic tools, etc., it's all a very closed arrangement which the manufacturers have, and they don't make all that widely available. This is something which the consumers and the users all over the world have been battling against the car manufacturers, and there's been a lot of forward movement in many of those economies and countries. In India, it still continues to operate as a closed market.
Right.
So what we found based on our investigation and based on what came to us is that this market is closed, it needs to be opened up, and that's the order that we've given, apart from the penalty, that you should make your parts, spare parts, more widely available, should not restrict the availability, you should try and standardize whatever can be standardized so that costs come down, rather than each horn for each car being of a different type, etc. And that there should be training facilities for the vast majority of standalone independent repairers across the length and breadth of this big country.
Right.
So that's the whole philosophy which has imbued this matter and this case, is to open up and reform the market, less and not so much impose a penalty.
Let me be the devil's advocate for a minute and go point by point. One of the things that the automakers say is that there is a certain IPR on these parts. How am I going to ensure the overall quality of my vehicle if I am going to open up the market, so to say? There is going to be a heightened risk of wear and tear. How am I going to give the warranties and the guarantees? Let's go point by point. How would you retort to that?
No, if there are issues of intellectual property, those need to be protected. Competition law does not say that those have to be totally ignored. It's just that the two have to work together, and those have to work in harmony. And if the intellectual property is in some jurisdiction outside, it doesn't automatically get protected in this country. And there is no reason because of that either to make the availability very restricted or to charge an abnormally high price, because that has intellectual property protection somewhere else.
Right.
But we recognize the fact that there are IPR issues where those who hold the property benefit or intellectual property benefit, they should get the benefit of that.
The other point that they raise is that there is no regulatory framework for spare parts in India. How do you deal with spare parts? There is no regulatory mechanism, there is no regulatory norm that specifies it, and which is why they are doing business like they do globally, or like they think is the right way to do. What would you say to that? Is it time that there is a policy in place for that as well?
Yes, in fact that's part of the order, that where we have suggested to the government and requested them to look at this aspect and try to bring up legislation and practices which put these matters on a greater level of safety footing, which is what many of the other countries have achieved. But we cannot really wait for all that to be achieved and then sequentially take up the opening up of the spare parts market. I guess the two have to work in some kind of manner where there is forward movement in both directions.
I'm going to now talk about the most sore point, and it always is the mullah. The moment you hit them with penalty, that's the charge that comes up. Over 2,500 crore rupees is a big amount. You say it could have been up to 10% according to the Act, but it's only 2%. The counter argument to that is that this is 2% of 3-year average revenue of those companies put together. Why should it not be the affected or the relevant revenue? Why should it be the revenue of, say, a Honda or a Tata Motors? Why should it be not revenue of spare parts per se? It is done in some advanced countries, isn't it?
Well, there are two reasons for that. One, the Act and the law as it stands doesn't recognize individual silos. It only talks of the turnover of the enterprise. So when we look at the enterprise, we look at one figure, which is the turnover. Secondly, I'm not even sure, and this point was not made before us, so therefore I'm not sure whether even some of the entities actually maintain the revenues, the audited figures of segment-wise revenues from spare parts, etc., etc., etc. And those were certainly not presented to us. But even if they were, the law focuses entirely on the turnover of the enterprise.
I want to just step back for a moment and ask you this question, that when the Act says up to 10% of revenue, is this then subjective upon the Commission to take a call whether it's going to be 2%, 6%, 7% or even 10%? Is that a dilemma that you battle with each time a case like that comes up? I mean, look at what happened in the cement case, the automakers, because it is subjective, because it is really up to the Commission to decide whether it's going to be 2% or it's going to be 8%.
Yeah, surely. When it says up to 10%, then what it means is there's an element of discretion. But discretion can never be unfettered. So discretion has to be based on the facts and circumstances of that particular case. If the violations are huge and humongous, then it could be on the higher side. If they are not all that serious, or they are such that need some intervention to correct them and improve the functioning of the market, then they could be lower, as in this case, where it's close, in fact, closer to zero than to the ceiling of 10%.
I also want to ask you a specific question, sir. I am sure in the course of this judgment, were there companies that came up to you and they wanted to take remedial steps? Were there companies that said they would discontinue these kind of practices and do something different? And does this order not have a differentiating factor? You've given an order for 14 companies, irrespective of the fact that there may be some who may have wanted to course correct.
Well, we did hear some viewpoints of that kind, but the position in our law today, unlike some of the other laws in other countries, is that there is no real scope for plea bargaining here.
Okay.
That's not provided for. Some other laws in other countries do provide for that, where you can settle with the offending or violating company. And if they agree to make changes, then maybe the penalties could be low or no penalty, etc. But in our case, as long as we find there is a violation, then we have to intervene and we have to take action to counter that. It could be on the lower side, it could be on the higher side, depending on the case.
While the law does not provide for it right now, but as the head of the Competition Commission, something that really regulates monopoly in the country, do you believe there's merit in the argument that they should be, if a company wants to make a course correction, if a company wants to get in a remedial step in place, should there be this bargaining power to do so before the order is passed?
Well, that would depend on the legislature and the government on how they want the law to be amended or tweaked. But if you ask my personal view, I don't think it's a good idea.
Why do you say so?
Because it would then open itself to a whole can of different interpretation, a can of worms, and whether something should have been done or not done, whether the motives and intentions were good or not so good. So in our kind of system, it's best not to provide for that flexibility.
Find us on Facebook at facebook.com/ETNow and don't forget to click the like button. You can also follow us on Twitter at ETNowLive. To stay updated with all our programming, hit the subscribe button on our YouTube channel by logging on to youtube.com/user/ETNow.